not to mention.
Yes.
Of course, if it may be
yes.
expressly
emphasize
conveyed to members of the union and all those who are here that neither the identities of both accused and their family members would joining the dots is concerned is to expose in whatever way. And this also is as a result of the report that I received this morning of a person who it is unknown whether the member of the gathering and or member of the person. On the previous occasion, photos of some of the family members of the accused and of specifically accused of accused was taken using a selfie by the person. That can be conveyed to everyone present. It is an order in that regard.
Thank you.
Lord, if I might just seek clarity from some confusion about the situation of identifying people. Because I understood his lordship's order, and in the normal practice of a criminal trial, the minor children may never be identified, whether it is today or at the later proceedings or 10 years from now, the children can never be identified. But the order regarding the identities of the accused is only an issue up until should there be a conviction. Once there's a conviction, the identities of the accused, not their families, but the identity of the accused, is no longer subject to that protection, as I understand. I'm not sure if that should be clarified as a right lordship at this stage.
Yes, Mr. Smith.
My Lord, from what I understand, they took pictures of this first accused as she stepped out of court yesterday. I don't have any ideas as how we can work around this, but I'm just stating it for the record.
Yesterday or on Tuesday?
Sorry, on Tuesday.
Okay.
Before yesterday.
My Lord, if I could the last time address that issue. I was informed of the photo that was taken. I spoke to I believe he's a journalist who took the photo. He deleted the photo and the photo was never published. So there was no contravention of his lordship's court order if we're talking about the same incident. There was a photo taken, but it was immediately deleted and never published.
Let me just make a ruling in that respect. If members of the media will recall, those without cameras, I made an order, one that the identity of the minor children or minor child should not be divulged. Either you use another name or a pseudonym in that respect. And as I've emphasized again on Tuesday, that even if it's for the future, whether today, tomorrow, or coming years, it should not be divulged in that respect. However, with regard to the identity of the accused, at this stage, just as I've indicated when we started the trial, is to avoid the training of the dots if they are known. However, as counsel for the state has indicated, once the outcome has come, it will be up to the media what they do with their names or whether they divulge. But however, I will say safely that in order also to protect the minor child and other children in that regard, please and please and please do not divulge. Thank you. We can start, yes. Introduction. On a winter day of the 25th June 2016, at around 7:30 in the morning, there lay the lifeless body of an innocent child called R, who was 3 years old, was found with some burns almost all over his body, and in addition, he had some blunt force injuries on his body. R was the son of the first accused and stepson to the second accused. First accused used to live in Nelspruit with her mother in one of the farms, and she was in a relationship with Ricardo Edwards. Out of this relationship, 2 sons were born, being J and R. The relationship of the first accused and second accused started around 2015. She came to stay with accused number 2 at Naturena. Around February 2016, R was injured. Accused number 2 indicated that he was injured while he was playing with the bicycle. Accused number 1 then took him to South Rand Hospital, where he was diagnosed as having a ligament injury. He was then taken to Baragwanath Hospital, wherein he was operated. Around March 2016, R had his femur fractured. He was then taken to Rahima Musa Hospital, wherein the doctor who treated him discovered injuries under his eyes, under his nipples, and on the rib cage. He was taken to Helen Joseph Hospital to be operated upon. He came back to Rahima Musa Hospital. As a result, the accused are facing 2 counts. Count 1. Contravention of Section 305, subsection 3, subsection A, read with the provisions of Section 1, Section 18, Section 305, subsection 6, Section 305, subsection 7 of the Children's Act 38 of 2005. Further, read with the provisions of Section 92, 25, and 270 of the Criminal Procedure Act 51 of 1977. In that, on or about the 31st of March 2016, and at or near a place, the exact location thereof unknown to the state, in the district of Johannesburg Central, accused unlawfully, intentionally abused, or deliberately neglected child R. Count 2. Murder, read with the provisions of Section 51, subsection 1, as well as Schedule 2 of the Criminal Law Amendment Act 105, 1997, and further read with the provisions of Section 92, 256, 258 of the Criminal Procedure Act 51 of 1977. In that or about the 25th day of June 2016, and at or near the residential premises situated at Naturena in the district of Johannesburg Central, the accused unlawfully killed a juvenile male person R. Alternatively, to count 1, a contravention of Section 305, subsection 3, subsection A, read with the provisions of Section 1, 118, 305, subsection 6, and 305, subsection 7 of the Children's Act 38 of 2005. Further, read with the provisions of Section 92, 257, and 270 of the Criminal Procedure Act 51 of 1977. In that, on or about the date and or near the place mentioned in count 1, the accused unlawfully, intentionally abused or deliberately neglected child R. Further alternative to count 2, a contravention of Section 305, subsection 4, read with the provisions of Section 1, Section 118, 305, subsection 6, and 305, subsection 7 of the Children's Act 38 of 2005, read with the provisions of Section 92, 257, and 270 of the Criminal Procedure Act of 1977. In that, on or about the date or and or near a place mentioned in count 2, the accused unlawfully failed to provide medical assistance to child R while able to do so. The provisions of Section 35, subsection 3 of the Children's Act states that a parent, a guardian, other person who has parental responsibilities and rights in respect of a child, caregiver, or a person who has no power until responsibility and rights in respect of the child, but who voluntarily cares for the child, either indefinitely, temporarily, or partially, is guilty of an offense if that parent or caregiver or other person A, abuses or deliberately neglects the child. In proving its case, the state called Dr. Hans Meyer, a pathologist who performed autopsy on the body of R, Dr. Yassat, who first saw R when he was in the hospital by accused number 2. On the 5th of March,
all right, you seem to have lost that line of that all-important judgment, and we'll keep
a police officer who visited the scene of the incident. Exhibit A to L was presented as evidence. The court will refer to the said exhibit during its deliberations. Exhibit A, it's a photo album compiled by Constable Magwasa. (202) subsection 7 of Act 51 of 1977.
All right, we seem to have lost that line once again. And as I said before, we'll just keep trying, but it's to hand down judgment in the case of baby Daniel, whose mother and her partner are being blamed for his death. Now, the EFF says it will challenge a court application.
Exhibit F, affidavit made by Ms. Marley Hebels, taken by Captain Markovic. Exhibit H, affidavit made by Constable Peter Munyandiswa. Exhibit J, statement or affidavit made by Ms. Marley Hebels in terms of the provisions of Section 60, subsection 11 of the Criminal Procedure Act 51 of 1977, made during her formal bail application. Exhibit K, transcript of the formal bail application, which was brought by both accused at the Regional Court, Johannesburg. Exhibit L, WhatsApp messages between accused 1 and accused 2 from 27 July 2017 at 04:20 to 27 July 2017 06:39. The two accused testified on their own without calling any further witnesses in respect of their respective cases. Summaries of evidence. The witness for the state. The state called Peter Munyandiswa to come and testify. In short, he testified that he is a member of the South African Police with the rank of a constable, and he's got 8 years being a police officer and stationed at the station. He was in the company of his crew member, Constable Zwan. They went to the accused house. They were welcomed by accused number 2, who informed them that he is the child's father. He asked him what happened, wherein accused 2 responded that the child fell into the hot water in the bathroom the previous night. When asked why he did not take the child to hospital, he told them that he did not have transport and it was at night and the child was not that much injured. He then took them to where the child was lying. They found the child on top of the bed and the child was fully clothed. When they looked at the child, they observed that his legs and feet were bent. His body was also bent, and below his neck he had marks that he was bent by something hot. They also found paramedics there. They then proceeded to go and open an inquest case or docket because the child had fell into a boiling water accidentally. There were other people in the house. He cannot recall if the mother of the child was also there. It was the paramedics who had certified the child dead. During the time he was cross-examined by accused number one's counsel, he was asked if he had touched the clothes of the deceased and whether the said clothes were fused to the skin of the deceased or whether they were loose from his skin, and he then replied that the said clothes were loose and they were not fused. He was cross-examined by accused number two counsel, and it was put to him that he will deny that he told them that he could not take the deceased to hospital because the child was not badly injured, and he will further deny that he did not have transport and it was already late. The witness was referred to his statement, which he has made involving the events of this matter. On his statement, he did not mention that the father of the deceased had informed him that he could not take the child to hospital due to the fact that he did not have any transport. Witness further testified that accused number two was in a fighting mood. Accused two denied that he was in a fighting mood. Will only admit that he had a confrontation with a duty officer. The witness further testified that after taking off the duvet cover, which was covering the deceased, he did some inspection on the deceased. That is when he observed the injuries on his body. You could see the forehead of the deceased was bent. The other witness of the state was Masinyani Sem Makwakwa, a member of the South African Police Service, holding a rank of a captain with the experience of 30 years being a police officer, a detective attached to Mondio Police Station. On this particular day, he was on standby duty. He received a call. He went to Naturena, the crime or the incident where the incident occurred, wherein he found two police officers. They informed him that the father of the child being accused to Emlyn Pillay said that the child was burnt with hot water. They then took him where the child was lying on top of the bed and further that the child was 3 years old. The witness was further referred to Exhibit A, photo number 10 and 11. He was shown the father of the child wherein he inquired from what happened. His demeanor was someone who was nervous and was very aggressive, and informed him that the child burnt himself on the bath with hot water while taking a bath until he passed away. He inquired from him why he did not call someone or even the ambulance to come and assist. He replied that he did not have any money to enable him to call the ambulance, and he started insulting him. He called him the F word. You do think that I'm the one who killed the child. That shocked him also. He observed the child, and according to him, the face of the child was bent as well as on the body. He was then called to another incident, and before he left, he instructed the two police officers to open an inquest docket. During cross-examination, he was asked if he did touch the clothes of the deceased, of which he replied that he did not. It was further put to him that accused one will come and testify that the clothes that the deceased was wearing were damp. He confirmed that he instructed the two police officers to open an inquest docket on the information that he has received from the deceased father that the child burnt himself while taking a bath, and have no evidence contrary to that which have indicated that the child could have been killed. During cross-examination by accused number two counsel, it was put to him that accused number two will deny that he told him that the child fell into the hot bath and stayed inside until he passed on. However, accused two will confirm and testify that the child fell into the bath. The witness was referred to his statement, and it was put to him that he did not mention on his statement that accused number two informed him that the child burned himself with hot water when he was in the bathroom. He indicated that he had written down just a summary of what actually happened. He did not write each and every thing that took place at the scene of the incident. It was put to the witness that accused two will come and testify that the child was still alive on the 25th of June, 2016, the day of his passing. He immediately shouted for the neighbors, and calls were made by members of his family and also by the neighbors for the paramedics, and further, he himself and accused number one, then they together with the neighbors tried to perform CPR on the child. The witness was also referred to photo number 10 and 11 of Exhibit A. He is not sure whether the bed cover was removed or not, as depicted on photo 10 and 11. The next state witness was Dr. N. Yashat, who indicated that she qualified at University of Cape Town in the year 2016. On the 31st of March 2016, she was working as an intern at Rahima Musa Hospital, which is the mother and child hospital, dealing with gynecology, obstetrics, and pediatrics. On this particular day, she was working at casualty. Was brought by one person that she described as a man who was not overweight or underweight. He was brown skinned, he had very little hair, he was bald. Is all she could remember. R came as an emergency at the hospital. After checking his vital signs, he found that he was stable and R was complaining of pain on the femur. He did an assessment of the femur. She discovered that there were no associated injuries. She discovered a number of injuries of varying ages. With regard to associated injuries of the femur, she discovered that there were none which looked like it had happened at the time of the injury of the left femur. Injuries, she said, were other way. One, R had a bilateral infrabrachial contusion. R had some bruising under both eyes. R had the bruising over the right nipple. R had the bruising on his left cage. These injuries were older than a day or two, and she was informed that the child received the said injuries when she walked into a door 2 days ago. She also discovered the scar on the left elbow, and an explanation that was given was to the effect that he suffered a said fracture during the preceding year, end 2015. He was treated at Baragwanath Hospital. In order to get answers to these injuries, she had to prompt answers from the person who brought the child to the hospital. She was given a history that R fell from the tree. She indicated that a fall from a tree can result in other areas of bruising, fractures, or abrasions. None of these were present. She is not sure whether she stabilized the injury or the fracture. Thereafter, R was referred to Helen Joseph Hospital for further treatment. He had to be seen by an orthopedic surgeon. After he was treated at Helen Joseph Hospital, he was returned back to Rahima Musa Hospital for further treatment and stabilization. After the child was returned back to Rahima Musa Hospital, she gave the social workers a statement. She indicated that the patient had a high index of suspicion of non-accidental injury. The reason she had this high index suspicion was the femur, friction by itself, more so when it happened to a child of between the ages 0 and 3. The other thing that raised her suspicion was the number of injuries that she had sustained previously of varying ages, as well as the elbow fracture, which had been treated in a different hospital. She did not know what happened to the said report. It was the last time that she saw the child at the time. She further confirmed that the bone of the child is pliable, that is, it is hard to break. The bone of a child, then, it is to break the bone of an, it's so strong than to break an adult bone. In order to break a child's bone, it will require a high velocity impact, which can be sustained from high walls, also be sustained from chalk. Falling from a different angle can also cause a fracture injury of a non-accidental injury. She further testified that if a person had a fractured femur or something like that, that will expect to find some bruising in the area of the hands trying to protect themselves from the fall. During the time she was examining the child, she realized that the child was very calm. He was not screaming, was not crying excessively, he was very withdrawn, and this surprised her, as this was not expected from the child who was seriously injured or an injury of a femur. And in her experience, a child is expected to scream, or any person who is injured or has his femur broken, he will experience a terrible pain and unbearable pain. The father of the child was speaking a lot to him, and he was very overly attentive to the child, and this surprised her also, since the father was not reacting like a normal parent who had his child injured, who wanted to know more of what is going to happen and the step that will be taken to correct the injury. During correct examination by a first accused attorney, it was put to her that accused 1 and 2 were not married and they were in a long-term relationship. They had different surnames, and accused number 2 was not the biological father of R. She was further asked if she had experienced that if the child's surname is different from the person who brought the child to the hospital, the child will not receive any attention, of which the witness indicated that she has not experienced like that, and according to her, they will always treat the child no matter who brought the child to hospital. It was further put to the witness that the reason why they brought the child to the hospital is that the couple were taking care of one of their friend's house, and that hospital was closer to where they were residing. At the time, she further confirmed that a femur fracture on a child of the age of 0 and 3 automatically comes to her attention as a suspicion of abuse. She was then asked with regard to the bruises on the rib cage, underneath the eye, and on the nipple. She confirmed that it is possible if a person walks on a closed door to receive those injuries. She further testified that accused number 2 was asked if he knows anything about the injuries on the rib cage and the nipple bruising. He indicated that he does not know. She further testified once the child has been admitted at casualty, to be transported to Helen Joseph and back is done by the hospital. And if admitted in a ward of Helen Rahima Musa, it is the responsibility of the physician or surgeon who takes over and decides to discharge or not to discharge the child from casualty. It was put to her that there was an investigation by the social worker who came to the accused place and said she's not taking the matter any further. She felt that there was no abuse, and a proper and reasonable explanation was given to her. With those injuries of varying ages, she noted earlier, they were not of the same date as the femur fracture. She testified that it might be possible that there might not be an associated injuries if a person falls from the tree. During cross-examination by accused number 2, counsel, it was confirmed that it is accused 2 who took the child to hospital. She confirmed that it was her first case of dealing with the femur injuries. According to her, her studies and any femur fracture is associated with high index suspicion of non-accidental injury, and she always looked for signs of non-accidental injury. She went on to testify that regardless of any other associated injuries, as indicated above, she will have still escalated the matter due to the fact that the behavior of the gentleman who brought the child to the hospital and how the child behaves with the fracture, it has just made her feel uncomfortable. The reason why she said the child was out of character was that generally when she deals with children who had fractures, they are more uncomfortable, they scream, they cry. In this case, the child was very quiet, very docile, he did not complain, and this child was withdrawn despite being so injured. It was put to her that R was quite a strong child who will not always cry over everything and presented a very quiet, resilient character. The next state witness was Mrs. Delia Markovich. She testified that her rank is that of a captain stationed at Mondio Police Station. On the 1st of July, she was asked to come and take a statement from the mother of the child who passed on at Najurena, which was in connection with an inquest docket which has been opened of the passing of that child under case number Mondio Cas 476/7/2016. She met accused number 1, who was in the company of her mother and another lady whom she does not know her. Upon arrival, they wanted to open a case against accused number 2. Accused 1 asked if accused 2 can attend the funeral of the child. She replied that there is no way the police can stop accused 2 from attending the funeral. She was informed that it was only through a protection order that they can stop accused 2 from attending the funeral. However, it can only be done on Monday, the 4th of July 2016. Accused 1 then received a call, of which she replied it. At that stage, she was angry, aggressive. She then said she cannot stop her from opening a case. She then replied that she can assist in opening a case, but that does not mean that it will stop accused 2 from attending the funeral. She then agreed to open a case of attempted murder against accused 2. They then proceeded to another office, wherein accused 1 proceeded to make a statement. She was making notes while accused 2 was speaking. After that, she wrote it neatly. Then she told accused number 1 that she can read it or she will read it back to her, of which she did read it back to accused 1. The case that was opened was MAR 33/70/2016. She was no longer involved with the matter. She was cross-examined by accused 1. Thereafter, accused 2 also cross-examined her. Accused 2 put it to her that he will come and testify that he was never charged with attempted murder. He will further inform the court that accused 1 came back to her voluntarily. The main state witness, Dr. Candace Geraldine Hans Meyer, herein referred as Hans Meyer. Dr. Hans Meyer's CV as to her qualifications, experience in autopsies and medical legal experiences was placed on record. She obtained a Bachelor of Medicine in Surgery in 2005 from the University of Witwatersrand, also known as WITS. She also obtained a Master's in Medicine in 2015, again from the University of Witwatersrand. She also obtained a fellowship from the College of Forensic Pathologists in South Africa in 2014, FC4 PATHSA, that is her specialty qualification. She is currently in the employ of the Department of Health and Social Services. She was first employed at Forensic Pathology Services in 2011. He has conducted about 2,500 autopsies, of which a ballpark figure could be about 15% has been children, estimating of approximately about 370 all children or pediatrics autopsies. Dr. Hasmeyer referred to her chief post-mortem report and explained certain of her observation made therein, which was accepted in Court Exhibit D with 2 annexes, Annexure A being a photo album and Annexure B being a radiology report. In terms of that report, she conducted a post-mortem on the 28th of July 2016 in respect of body number 13812/2016, the body which is not in dispute being of that of R. As per standard procedure of the department, any child case that is regarded as irregular, 2 pathologists are then asked to look over the case together in consultation with each other. Dr. Mweng attended the post-mortem examination as a second pathologist. For example, a case of a child that has died suddenly and unexpectedly, this is a phenomenon known as SUDI, sudden unexpected death in infancy. In a case where the history has been given and seems incongruent with the post-mortem findings, the post-mortem examinations. When she started post-mortem examinations, which include autopsy, she started off the session by receiving a case docket. Housed within the case docket is an SAP 180, which is the form that the police fill at the scene of the death. This form will give you or give her the demographics of the individual, the place of death. The demographics, which included the identity of the individual, it is also made provision for mechanism of death, for example, blunt force injury versus sharp force injury, or possible natural cause of death. This includes suicide, homicide, or undetermined or accidental. And lastly, it made provision for the personal belongings that are found on the deceased or in the possession of the deceased. The report will then also contain a form that is filled out by the forensic officers, who are then sent to pick up the deceased from the scene of the death. She will peruse the said report prior to the post-mortem examination, which includes the external investigation, as well as the performance of autopsy and the performance of any auxiliary test. Prior to the performance of the autopsy, one is fairly limited by what is written in the forms. For example, before the performance of this autopsy, all that she had was a very scanty information filled on both SAP 180 and the form filled in by the forensic pathology forensic officer that went to fetch the deceased. Once one has perused the docket case file, they then went into the autopsy suite where the body had been laid out, and then they start the performance of the post-mortem examination, which includes, among other things, viewing of the body, undressing the body, and doing a physical examination of external wounds and injuries. At the time of the post-mortem examination, when she viewed the body, she realized that she was dealing with more than just burns to the body. At that time, she decided to elect to send the deceased for a skeletal survey. She explained that a skeletal survey is a series of X-rays that are taken of the deceased before the start of the autopsy process. The reason they do this is that they should exclude any artifactual matters. All the skeletal surveys are performed by the pediatrics radiology academic hospital. She then repacked the body and then handed the body over to a forensic officer to transport to the hospital for the radiological examination. Therefore, the post-mortem examination was then only concluded the following day. It is also common practice within the department to call the investigating officer in whose jurisdiction or who is responsible for the case to attend autopsy and the performance of the post-mortem examination. It was therefore on the 27th of June that she telephonically notified the investigating officer of the possibility of this case being regarded as irregular, and therefore requested his attendance during the performance of the post-mortem examination. What she learned from the skeletal survey that she had not picked up on examination was the fact that the deceased had a left mid-femoral fracture. Furthermore, she also learned that he had a left pneumothorax. She had already seen that there had been some sort of surgical intervention to the elbow, which was confirmed by the comment of the left medial distal humeral corner structure. She testified further that she did meet up with the family of the deceased. If she remembered that it was two women were escorted to her office by a security guard. One of the individuals was the mother, who appeared distraught, upset, followed by an individual who she then gathered was the grandmother or a mother. She was not sure whether it was a paternal or maternal. She might have been the maternal grandmother because she said she should explain to her daughter what the cause of death was. At that stage, she explained that there was no cause of death as the post-mortem had not been done, and that if she wanted to see the deceased, she was more than welcome to view the deceased. She further added that if she needed any further information, she was to contact the investigating officer. Dr. Hans Meyer then referred to her chief post-mortem report and explained certain of her observations made therein. As stated above, the time of performing our post-mortem examination, she had conducted approximately 2,500 post-mortem examinations, of which approximately 15% were children or pediatrics. Dr. Hasmeyer described in detail and explained the set injuries found or seen on R as per Exhibit D. 1. In respect of external appearances of the body of R, paragraphs 4.1, bends. As per paragraph 4.1 of Exhibit D, his body was at least 60% partial and to full thickness bends, as explained that the severity of the bend depends on the degree of temperature of the offending substance as well as the time exposed thereto. 2. A superficial bend is to the top layer of the skin. A partial thickness bend goes beyond the top layer into the lower layers of the skin, and a full thickness bend goes through all the layers of the skin and affects underlying tissues. 3. 20% wounds of a child is associated with a high level of death. 4. In addition to the bend wounds, R also had splash marks over his lips, nose, chin, and forehead, as well as tibial marks on the lateral and dorsal aspect of his feet. 5. The wounds were not dressed or bandaged. 6. A bend wound amounting to 60% coverage of the body will result in an almost immediate seepage of fluid. 7. R had sustained any superficial wounds. R had not sustained any superficial bend wounds. The bend wounds were consistent with having been caused by hot water or a hot fluid. 9. Certain parts of R body, based on the severity of the wounds, were exposed to the water or fluid for longer period of time than others. The entirety of the bend wounds was inflicted while R was alive. 11. Although unable to specify the temperature, the water or fluid that inflicted the wound must have been scalding hot. 13. Having sustained bend wounds to more than 20% of the surface area, a body will undergo 3 processes simultaneously. Namely, first, there will be a breach of the epithelium resulting in leakage of fluid, which is referred to as plasma capillary leak. 60% surface area bend will result in significant loss of fluid. Secondly, internally the body undertakes various compensatory mechanisms which affect the adrenal glands, the vessels, the heart, and other organs of the body. Fluid shifts between cells as they try to maintain equilibrium. Thirdly, the surge response, which is an inflammatory response, is a process of the body trying to save itself and working harder to do so, which can ultimately lead to the heart failure. The 3 processes happening together is referred to as burn shock. The time frame from sustaining the injuries until the time of death could be as little as 12 hours. The pain experienced in sustaining such wounds will be catastrophic. Timely medical intervention after sustaining such wound could have significant effect on chances of death. R was naked at the time the burn wounds were inflicted. Dressing R would have been significantly painful. Paragraph 4.2, abrasion of the right temporal. An imprint abrasion of the right temporal region, as per paragraph 4.2, Dr. Hans Meyer explained. The wound is depicted on the photo on page 14 of Exhibit D. This imprint abrasion is a blunt force injury consistent with an impact of a hard object with a rough surface. 3. This was acute wound which was likely 24 to 48 hours old. Paragraph 4.3, a semicircular shaped bruise. A semicircular shaped bruise over the left forehead as per paragraph 4.3. She explained the wound is depicted on top paragraph on page 15 of Exhibit D. This injury was consistent with a blunt force injury. The bruise was only a few hours old. Paragraph 4.4, irregular faint bruise left forearm. An irregular faint bruise over the posterior aspect of the left forearm, as per paragraph 4.4. She explained, this injury is consistent with a blunt force injury. This injury was 2 to 3 days old. Paragraph 4.5, another irregular faint bruise. An irregular faint bruise over the posterior aspect of the left forearm. This wound was 2 to 3 days old also. Paragraphs 4.6 and 4.7, discoid bruise on left and right arms. A discoid bruise over the lateral aspect of the left arm. A discoid bruise over the anterior aspect of the right arm. Dr. Hans Meyer stated that in respect of wounds 4.6 and 4.7, these wounds were blunt force injuries consistent with having been grabbed by somebody on the arm. The wounds were fresh wounds. Paragraph 4.8, focal bruise, the right buttocks. A focal bruise below the right buttocks, as paragraph 4.8, the focal bruise is consistent with the blunt force injury. It was difficult to estimate the time frame for this injury, which is depicted in the photo, bottom photo of page 16 of Exhibit D. Paragraph 4.9, 6 contusions over right upper back. 6 focal contusions over the right upper back, mid back, and left flank. She explained the wounds are consistent with the blunt force injury. Due to involvement of the bands, it is difficult to determine the ages thereof. These wounds, as well as the wounds in paragraph 4.8, were inflicted while R was alive. The wounds are consistent with 6 separate applications of blunt forces. Paragraph 4.10, bruise over right cheek. A focal bruise over the right cheek. She explained this bruise is consistent with the blunt force injury. This injury is depicted on the bottom photo on page 16 of Exhibit D. The burn wounds complicate any possible age determination. Paragraph 10.11, a linear scar over left elbow. A linear scar of the left elbow. Previous surgical intervention had taken place. The eyes are sunken bilaterally. She explained in respect of this wound that this indicates that R was dehydrated. The dehydration is directly attributable to the burn wounds. Description and discussion of injuries to the skull and scalp included There is a 30.50 millimeter of a focal hemorrhage over the right occipital region, a focal hemorrhage over the left forehead, a focal hemorrhage over the right temporal region, and a focal hemorrhage over the left parietal region. This was in respect of paragraph 6 of Exhibit D. The 40 by 43 millimeter focal hemorrhage over the left forehead correspond to the semicircular C-shaped bruise over the left forehead. That is paragraph 4.3 of Exhibit D. The 40 by 40 focal hemorrhage over the right temporal region correspond to the imprint abrasion over the right temporal region as per paragraph 4.2. The remaining 2 focal hemorrhages were not picked up on external examination. All of the hemorrhages are consistent with blunt force injuries. Under the heading intracranial contents, the following description and details were provided. 25 millimeter of clot blood forming a subdural hemorrhage situated over the parasitical region of the parietal lobes bilaterally, as well as global swelling of the brain, as paragraph 6 of Exhibit D. In this regard, Dr. Hans Meyer stated, 1. A subdural hematoma is a collection of blood below the dura covering the brain. 2. Epidural hematoma is a bleed above the dura. 3. In order to suffer an epidural hemorrhage, a hard direct force is required. 4. A fall from height comes into this category of a hard direct force. A fall from height would, however, to be from at least 3 meters. A subdural hemorrhage is caused by a deceleration, acceleration, or rotational force. Epidural and subdural hemorrhage can be caused by blunt force injuries. The various degrees of force are: firstly, a mild amount of force, incomparable to a simple fall, possibly causing a bruise or a scalp laceration. Secondly, a moderate amount of force is comparable to tripping down the stairs and bumping of the head against the table, which may or may not cause a laceration or bruise and is unlikely to cause atriocerebral or cerebral hemorrhages. Thirdly, a severe or large amount of force is comparable to a fall from height of a car accident, which will not necessarily cause a skull fracture, but will likely cause an intercerebral hemorrhage. A child's skull can withstand an enormous amount of force before it fractures. A large amount of force is required to cause a cerebral hemorrhage. The subdural hemorrhage was inflicted a minimum of 24 hours prior to R's death. All cerebral hemorrhages required medical attention. Under the heading chest and diaphragm, paragraph 10 of Exhibit D states as follows. There is a linear fracture of the lateral aspect of the 8th rib of the left chest cavity. There is evidence of associated hemorrhage of the fracture site and of the intercostal muscle. There is no collection of blood-stained fluid in the chest cavity. These injuries were inflicted on R while alive. A rib fracture in child can be caused by a direct force or a compression force, which means a lot of force was required to fracture a child's rib. In addition to the rib fracture and lung contusion, there was a pneumothorax present. A pneumothorax is a collection of air in the chest cavity, which is regarded as surgical emergency, always requires medical intervention. The pneumothorax was an acute injury. Of the individual mechanism of injury, namely the blunt force head injury, the blunt force chest injury, and the burn wounds could have individually caused the death of R. According to Dr. Hans Meyer, R suffered at least 15 separate applications of force. In respect of R's previous elbow injury, Dr. Hans Meyer stated the fracture could have been caused by a blunt force injury, the grabbing or twisting of R's M. A moderate amount of force is required to inflict such a fracture. In respect of the femur fracture, she testified that the femur is commonly known as the thigh bone. The large amount of force is required to fracture a femur of a child. She concluded her evidence in chief by stating, again looking at the multiplicity of the wounds, different regions, different wounds, different ages, these wounds are consistent with none than accidental injury syndrome. During cross-examination of Dr. Hans Meyer by accused one attorney, she was confronted with the following version on behalf of accused one. In respect of the elbow injury, on Sunday afternoon during February 2016, whilst she was inside caring for their infant, R was outside the house in the company of accused 2. She was informed by accused 2 that R fell from his bicycle and complained of pain. She gave him medication. She then took R to the South Rand Hospital on Monday morning, where X-rays were taken of R's elbow, and she was informed that it was a torn ligament. However, on Thursday, R was still in pain. Then on Friday, she took him to Chris Hani Baragwanath Hospital, wherein another X-ray were taken, and she was then informed that R had suffered a fractured elbow and required a surgery. In respect of a femur fracture, on the 31st of March 2016, accused 1 was inside the house caring for the baby. Accused then 2 came into the house stating R had fallen from a tree. R was hospitalized, treated, and released. Pertaining to R's death and the discovery thereof, accused 1 returned home from work on Friday evening at approximately 19 hours when accused 1 and 2 had argument which almost got physical. During the argument, accused 2 informed accused 1 that I fucked him up for good. She then went to check on R, wherein she saw a reddish mark on his cheek and he looked dizzy, disorientated. Accused 2 then said the reddish mark was from the pillow and the reason he looked disorientated was because he just woken up from sleep. She then asked R if he is okay, of which he replied that he is okay. Again during the night while accused 2 was sleeping at around 11 p.m. on Friday evening, accused 1 then went to R and asked him if he was okay. R replied by saying, I am fine, mommy. He confirmed that he was okay. That is when she went to sleep. During the night, at unknown time, R said he wanted to go to the bathroom. Accused 2 asked his brother to open up for him so that he could go outside and relieve himself on the garden. The bathroom was at the main house. They were sleeping at the back room. R opened the door and went out of the room. Accused 1 fell asleep. Accused 1 was woken up by accused 2 at approximately 7:30 on Saturday morning when accused 2 was calling the name of R. She then rushed to where R was. At that time, R was still on top of bed. She noticed that R was not breathing properly. Accused 1 saw a red mark on the left of R's face. She further noted that R's clothes were damp. Accused 1 picked R up, put him on the floor, and attempted CPR. Accused 2 and a neighbor thereafter also attempted CPR. It was further put to Dr. Hans Meyer that R did not have any burn wounds at the time accused 1 spoke to him at 11 o'clock p.m. Accused 1 did not undress R at 11 o'clock or at any stage when she was checking upon him. Accused 2 version was put to Dr. Hans Meyer as follows. Accused 2 heard R screaming as well as noises that sounded like R was hitting a wall or something. Accused 2 then rushed into the bathroom wherein he found R in the hot bath water. After accused 2 removed R from the bath, he dried him with a towel. Thereafter he applied the white ointment from a tube. When accused 2 removed R from the bath, the burn wounds did not appear as red as they do in the photos of Exhibit D. The imprint impression might have been suffered by R hitting his head on the tap while falling into the bath. Accused 2 will explain that the rib fracture might have happened during the resuscitation. During February 2016, R was riding his bicycle in the yard with his brother Jay in the presence of accused 2. Accused 1, in cross-examination, having looked at an old cellular phone, realized that R actually sustained an elbow injury during January 2016. She was in the main house caring after their little daughter, Elle. She heard R crying and went outside. She found R crying with accused 2 comforting him. They then told her that R fell from his bicycle. She noticed that R's elbow was hurt and the skin was scratched. She gave him stop pain at around 4 or 5 o'clock. R, however, continued playing for a while after the incident. The next morning, accused 1 was worried about the swelling to the elbow. He then took R to the South Rand Hospital at approximately 8 in the morning. After x-rays were taken, A doctor informed her that R had a torn ligament. R was not admitted in hospital. They went back home, and on the following Thursday, the elbow started swelling again. She then made necessary arrangements to take R to Chris Hani Hospital on Friday. A doctor eventually informed them that R had his elbow broken and required surgery. R was admitted in hospital and eventually went the operation 2 days later. R spent 4 days in hospital, although R did not have a complete cast. He had to rest for 6 weeks. In respect of the fractured femur, she testified that on the 31st of March 2016, she, R, J, L, and accused 2 temporarily stayed at accused 2 Kanson's house. The location thereof was unknown to her. She and L were asleep in the bedroom. Accused 2 woke her at approximately 2 p.m. and stated that R fell from a tree. R was lying on the bed, crying, and confirmed that he fell out of the tree. Accused 2 contacted his cousin who transported him, that is accused 2, and R to the hospital. R was admitted and accused 2 returned to the house at approximately 10 p.m. She visited at least R twice or 3 times a week at the hospital. In respect to other bruises, as testified about by Dr. Yas, accused 1 stated she noticed the bruises under R's eye and put an ice pack on it. Accused 2 and R explained that the bruises were sustained when R ran into a sliding door. The bruises under the eye were seen by accused 1 the day prior to R falling off the tree. She noticed the injury near the right nipple and left rib cage on the day R fell out of the tree. She testified that a social worker was appointed to investigate possible abuse of R. The social worker informed her she could not find anything untoward. Approximately a week after R was discharged from hospital, another 2 persons attended the house making further inquiries about the potential abuse. The 2 persons informed her that they considered the matter closed as they could see the boys were happy. She testified about the events of the 23rd of June 23 as follows. When she was at her place of employment, R was home ill and accused 2 was taking care of him. Upon her arrival home, accused 1 found Auntie Marilyn in the presence of R and J, who informed her that the boys had already eaten. She supervised the bathing of R and J and bathed L as she did like always every evening. The boys slept in the middle of the middle bedroom in the main house, where accused 1 put them to bed at 8 p.m. Herself and accused 2 slept at the back room with L. She did not have any suspicion of poor treatment of R by accused 2. On that particular day, the 23rd of June 2016, she had an argument or a disagreement with accused 2. However, she could not recall what was the disagreement all about, but it never became physical. This led to accused leaving the room and going outside to work on his bikie. He only returned back into the room after she had fallen asleep. The following morning, she did not wake up the boys as Jay was on school holidays and R was off sick due to flu. She requested accused 2 that he should assess if R was well enough to attend school. She proceeded to a place of employment. With regard to the events of the 24th and 25th of June 2016, she testified as follows. She arrived back home around 7 p.m. Jay opened the garage door for her, and Jay went and sat on the couch next to R, who was sleeping. She was not concerned about R being asleep since she was aware that R was sick and had taken medication. She went to hang up her handbag, when accused 2 approached her from behind and handed L to her. Accused 2 was immediately aggressive and pushed her into the corner. Accused 2 pushed his fist into her neck or chin and informed her that he would show her what it is to be beaten. She was too scared to call for help and merely did what accused 2 told her to do. Accused 2 was extremely upset and using vulgar or profound language. Accused 2 later pressed her into the bed and pushed his finger into her face. Once Elle was asleep, she asked accused if she could go and smoke. Accused 2 agreed. At this point, she was outside the room, standing by the door. R and J were on the couch sleeping. L also was sleeping. Accused was sitting on the bed. Accused, she testified, well, looking at R, then said, I fucked him up for good this time. She immediately went to R, woke him up and asked if he was okay. R confirmed that he was. At that point, she noticed a red mark on the left side of R's face. The said mark was near the middle of his temple towards his ear. She was under the impression that the red mark was as a result of R sleeping on his left side. She confronted accused 2, who merely stated that R was sleeping. At that time, R was fully dressed and she could only see his face. She was satisfied that R was okay and she sat on the bed. Accused 2 was continuously aggressive towards her and repeated his threats about showing her what it was to be beaten. Accused 2 did not allow her to freely move around the room. Accused 2 later turned off the television and stated that he is going to sleep. She can also go to sleep. She then waited until accused 2 was twice or R again and confirmed that he was okay. She then went to sleep. Later during the night, as already testified, the exact time she cannot recall. She heard R calling. She inquired from R what was wrong. R said he wanted to go to the toilet. She told him he can go out. He saw R standing up and opened the door, but was not sure where he went since she went back to sleep. In the past, whenever R wanted to pass water, she will go in the garden. He will go to the garden to do that. She then went back to sleep. The following morning, on the 25th June 2016, at around 7:30, she was woken up by the anxious voice of accused calling, saying, R, R. She jumped out of the bed and went to the sleeper couch. R's face looked completely different to the night before. There was a mark on his right cheek that was not there the night before. Mr. Smith, can you check the client leaves is fine?
Can we please adjourn the court for 5 minutes or so, so she
court will take a short adjournment. At the time it's 25 to 12. Court adjourned.
Kimi lazo? Şabuzet. Evet.
And I don't know why you have to try it. I sent it to block the rest.
Sen, Ankara Petrol'e. Good.
I'm a very bad
Tommy, what happened to 12?
and I wanted to give it to the I lost it. So now I draw it and then I take pictures of it. But I didn't. But you can't say that the prosecutor then I'll get in trouble. I'll try and draw this through it. Might not concerning this might not come up this week. Yeah, I'm training for progress, so I'm taking work something. Yeah. And I've now followed every journalist who's here on Twitter to show you also that extra problems.
I like the optimism. Christmas spirit.
and burned himself. This was the first time accused one heard this explanation. One of the police officers who attended the residential premises said to accused two that he was negligent, causing two accused to become angry. She did not get involved with the police due to the confrontation. Her body was collected and removed. The events that transpired after the passing of R. Accused one testified further that our biological father was informed of the death and visited the residential premises same day of the passing of R. Mr. R.E. and accused two had confrontation with each other, and they had to be separated from one another as they wanted to fight each other. It was decided that Jay should live with his biological father, Mr. R.E. A lady who identified herself as Miss Michelle Pelso from Community Policing Forum arrived at the house saying he had come to remove L. She, in the company of her mother, that is accused one, went to Johannesburg mortuary where Dr. Hans Meyer said she could not tell her anything and denied her the opportunity to see R's body. She met with her family, including her father, at Irene Mall. She told them that she did not know what happened to R, but explained the events of the 24th of June 2016 to them. She further explained to them how accused two had treated her during the week of passing of R. She explained that she inquired from accused two why he said those words and did these things he did. She specifically related to her family how she asked accused two about his statement, "I fucked him up for good this time." Accused two initially informed accused one that he was merely trying to scare her, but then later denied making such a statement. As she was relating the whole event to her family, she then realized something did not make sense. Accused one contacted Michelle Pelser, who made arrangement for accused one to attend Mondoa police station. She went together with her mother and father, as well as her father's wife. They met Captain Markovic at Mondoa police station. Captain Markovic was under the impression that accused one intended to confess her involvement in R's death. She informed Captain that she was there to open a case against accused two. She contacted her sister, who informed her that the police cannot refuse her to open a case against accused two. She returned to Captain Markovic and they eventually went into another office where she made her statement. Captain Markovic initially took notes and then wrote the affidavit, Exhibit F. After completing writing, she offered her if she wants to read it or she can read it, of which she just sighed. She took exception to paragraph 2 of Exhibit F, as it did not reflect what she told Captain Markovic. She expressly stated that she agreed with the content of paragraph 6 of Exhibit F. She confirmed the content of affidavit she presented during her bail application, being Exhibit J. She further submitted a copy of the record of the bail proceeding as Exhibit K. She later produced a document of a WhatsApp conversation between herself and accused 2, being Exhibit L. And that was accused 1 case. She then closed the case without calling any further witnesses. Accused 2 case. He agreed with accused 1's description of how their relationship started and progressed. R and J referred to him as Daddy, though it took J slightly longer to do so, but with regard to R it was spontaneous. He never asked them to call him dirty. They did that on their own. Him and accused one will argue with one another on numerous occasions about accused two ex-girlfriend. He described accused one as being paranoid in that regard. He felt like he could no longer take the strain of the continuous arguments. The trust relationship between them was severely affected. Regarding the previous elbow injury, accused two stated he was working underneath the car while R and J were playing on a bicycle. Accused one was inside the house. He heard the bicycle fell and R coming down. He picked him up, consoled him, and took him inside to accused one. He returned outside and was unaware, unsure what accused one did. He could not recall the details of how, when, and where R was taken to hospital. He denied having inflicted the elbow injury. In respect of the fracture femur, both accused with the three children were house sitting. He was outside cleaning a motorbike, and R was also playing outside. J was watching television inside the while accused one and L were sleeping. Accused two heard a bang and immediately ran to R. He was crying, but not as much as when he fell in the bath. He could feel that R's leg was swaying different. As he only had the motorbike, he called a friend to transport R and himself to hospital. The staff at the hospital, having seen his driver's license, noted that the surname P, the bruises to R's eyes were inflicted when R ran into a glass door while chasing kittens out of the house. He was unaware of the other injuries on R's body. He denied having inflicted the femur fracture. Accused two versions of events relating to R's death can be summarized as follows. He had an argument with accused one about his ex on Thursday evening, which was left unresolved. R and J both stayed home from school on the Friday as they were sick, while accused one went to work. They had breakfast and then the boys watched a movie. At one stage, R came and inquired what was he doing. In the afternoon, he decided to bath the boys before accused one got home. Having instructed J to get pajamas ready, he and R went into the main house. He opened the hot water tap and opened cold water tap, but only slightly or little. He instructed R to get undressed while he went to fetch J. As he was walking down the passage, he heard a banging noise and the sound of something falling into water. He immediately turned back to the bathroom. The banging continued. He found R standing in the bath with his arms reaching up. He grabbed R out of the bath and realized that the water was very hot. He noticed that the cold water tap was closed. He took R to the outside room, dried him with a towel, and applied an ointment for burns. He then asked R what was he doing to make him fall into the water. He said he wanted to reach the stone on the side of the bath. That is when bath time was cancelled and R dressed himself in underpants. Ben, having arrived with L, told R and J that they must go dressed as it was cold. Once R and J wore their pajamas, they, along with accused 2 who was holding L, watched a movie. R and J were on the couch while he sat on the bed with L. Later, J opened the door or garage door for accused 1 on her return from work. R was already dozing off at that point. The previous day, argument between him and accused 1 continued. He put one of his fists on accused one's cheeks to show that he could also use his power over her. Accused one asked in a sarcastic manner whether she may go and smoke. As accused one was standing outside smoking, he was seated on the bed with L lying behind him. He then said that our relationship is fucked for good this time. After this exchange, he then informed accused one that R had fallen into the bath and she must check on him, which she did. Accused one inquired from him what was wrong with R. He responded by saying that R was sleeping and had just woken up. They kept out of each other's way. He was in and out of the room until he went to sleep at about 9:30 p.m. He, at an unknown time, he heard accused one tell R that he could go to the toilet. He woke up on the 25th of June 2016 and noticed R was lying off the couch. He then called R and he did not respond. He rushed to him, picked him up, placed him on the floor and attempted CPR. Accused one was hysterical. He noticed some air coming out of R. He stopped doing CPR and accused one shouted at him to do something. Accused one picked up R and ran outside to his mother at the main house. He went across the road to look for a paramedic neighbor. The neighbor was not home, but his uncle telephonically contacted the paramedics. He went back to the uncle to make sure that the paramedics were on their way. He returned to find his mother removing R's socks. Accused two, having looked at the photos of R burn wound, said the burns were not initially as bad as they appeared in the photo exhibit D. In denying having caused R burn forces, he explained that R will often bump himself and not complain. R will only inform them of his injuries if he was bleeding. He checked on R after he fell in the bath. He did not complain about any pain at that stage. In respect of the events that unfolded after R's death, accused two stated. Accused one stayed with her family for a few days. Accused one changed the venue of our funeral without informing him. She wanted to return home, but her family would not allow it. They continued having contact with each other. Accused one started asking legal formal questions regarding our injuries. He was unable to confess accused one, as her family would not stop accept him due to his race. Accused one later returned home unannounced. He confirmed the WhatsApp messages as per Exhibit L, but unable to recall the content. He believed accused one had deleted certain messages. Although accused one used the words "I killed R," he maintained contextually it was not a confession. Accused two, in spite of his allegations in Exhibit L, held the view that accused two was a good mother that did not abuse alcohol. As a parent, yes, at one stage he did previously discipline R by striking him on his buttocks. After R's death, on an unknown date, he once hit accused one as she was disrespecting him and making herself cheap while intoxicated. He then closed his case without calling any further witnesses. Argument by the state and defense. Counsel for the state and counsel for accused two filed their written heads of argument some time back. However, accused one's attorney only filed his head on the day of address on conviction. The court appreciated the written heads of arguments. Counsel for the state succinctly summarized the evidence, and the court is highly appreciative of that. The state and the defense addressed the court on conviction, and they each summarized the arguments on record. The court will not repeat every submissions made on their written arguments and or during their submissions in court, safe to state that the court, where necessary, will refer to some of the points raised on their arguments. Issues in dispute. The sole issue for determination by this court is, did accused jointly or individually, unlawfully and intentionally cause the death of R, or through their negligence cause the death of R? There is no direct evidence that any or both of the accused caused the death of the deceased, that is R. The court has to draw inferences from the evidence or facts that both or any one of the accused deliberately caused the death of R. The state relies on circumstantial evidence in proving the guilt of the accused. The court takes cognizance of the warning that has been echoed in several decided cases that a distinction must be drawn between drawing of inferences and making assumptions when dealing with circumstantial evidence, like what was stated in S versus Cooper, 1976, 2 SA 875T, in which it was stated, when triers of fact come to deal with circumstantial evidence and inferences to be drawn therefrom, they must be careful to distinguish between inferences and conjecture or speculation. There can be no inference unless there are objective facts from which to infer the other facts which are sought to establish. In some cases, the other facts can be inferred with as much practical certainty as if they had been actually observed. In other cases, the inferences does not go beyond reasonable probability. But if there are no positive facts from which the inference can be made, the method of inferences fails and what is left is mere speculation or conjecture. Evaluation and findings. It is the duty of the state to prove the case against the accused beyond a reasonable doubt. A conspicuous of all the evidence is required. Evidence that is reliable should be weighed alongside such evidence as may be found to be false. Independently variable evidence, if any, should be weighed to see if it supports any of the evidence standard. In considering whether evidence is reliable, the quality of that evidence must of necessity evidence, if any. Evidence, of course, must be evaluated against the owners on any particular issue or in respect of the case in its entirety. In this regard, see S. Toronto 2003-1, SACR 35 SCA, paragraph 9. Applicable legal principles. The concept circumstantial evidence has become virtually synonymous with the landmark decision in S versus Blom, 1939, AD 188. This decision has been quoted in several cases and it stated clearly that certain rules of logic have to be complied with once inferences are called for. At page 202 of the same case, it stated that in reasoning by inference, there are two cardinal rules of logic which cannot be ignored. One, the inference sought to be drawn must be consistent with the proved facts. If not, the inference cannot be drawn. Two, the proved facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. If they do not exclude other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is correct. Expert evidence. As the court had indicated above that the main witness for the state was Dr. Hans Meyer, who performed an autopsy of R. She was testifying in her capacity as an expert. The state has also made the submission that also Dr. Yachat's evidence be accepted as that of an expert. Our law has, through various decided cases, developed principles applicable to admissibility of expert witness evidence. The list is not exhaustive. See in this regard, Holson versus Ruock, 1997 for SA 766 WLD at 771H 72773, C. See also Perry versus Naidu 2017 JDR 1732 GJ at paragraph 18. The court must be of the opinion that the person is competent to testify as an expert. The expert testimony must comply with three basic requirements. A. The basis of the expertise, the expert qualifications, experiences, expertise, and knowledge must be put before the court. The basis for the opinion and reasons for the opinion must be put before the court, which must be based on the facts in the case. C. The opinion of the expert must not displace that of the court. The prime function of an expert is to guide the court to correct decision on questions falling within the expert specialist field. Also in this regard, see S versus House, 1967, 4 SA 527, EC on 528D. See also R versus Velbro, 1957, 3 SA 223A, and S versus Hasbro, 1969, 2 SA 624A. The qualifications of Doctors Hans Meyer and Yachat have already been stated above. Same will not be repeated here, save in stating that it was for the first time that Dr. Yachat testified before court. He had shown that she does understand what she was testifying about. She mostly testified about what she observed during the time she was examining R at Rahima Musa Hospital. When asked for her opinion, she was able to refer to her studies and what she had read regarding the fact of which she was asked to give an opinion on. The opinions of both doctors were based on the fact of the case. They were not one-sided because they were called to testify on behalf of the state. They were not biased. In the matter of Stock versus Stock 1981, 3 SA 1288, the Appellate Division at 1296 held that an expert must be made to understand that he is there to assist the court. If he is to be helpful, he must be neutral. The evidence of such a witness is of little value where he or she is partisan and consistently asserts the cause of the party who calls him. These facts are either within the personal knowledge of the expert or on the basis of facts proved by others. The expert must properly identify his or her sources of information and set out a factual basis upon which the opinion is based. Dr. Hans Meyer was called on her specialization, skill, and knowledge as a pathologist. The court is of the view that Hans Meyer is not in dispute. Her whole evidence is very important to the court. It is the crux of the state evidence in respect of the charge that they have referred against the accused. It is not in dispute that R suffered the following injuries. He had an elbow injury. He had a fracture of the femur. He had a bilateral infraorbital contusion. He had some bruising under both eyes. He had a bruising over the right nipple. He had a bruising on his left rib cage. He had and about 15 blunt force injuries all over his body. He had a blunt force chest injury and he had the bends of about 60%. What is in dispute is did any or both of the accused intentionally cause the said injuries? And secondly, was R abused? According to the evidence, Whenever the above-mentioned injuries took place, R will be in the company of accused 2. Accused 1 will be informed after the incident had happened or taken place. Accused 2 testified that while he was busy under his motor vehicle, R was riding a bicycle and he saw R falling down, or he heard R falling down, and he complained about his arm. He then took him to accused 1 who was inside the house. There is no evidence as to how high was this bicycle. Was the evidence However, according to Dr. Hans Meyer, the said fracture could have been caused by a blunt injury, the grabbing or twisting of R arm, a moderate Meyer. This injury was not caused by falling from a bicycle, but it was caused by a person or a human being. There is no evidence as to whether there were any associated injuries like scratches on the arm or anything that will indicate that really the child fell from a bicycle. Except accused number 1 also said that when he looked at the accused of R, there were some other scratches. The femur. Also in this aspect, well, accused 1 was and informed me that R had fallen from the tree. When Dr. Yachat examined R, she observed that there were no associated injuries of a person who had fallen from the tree. She testified that it is expected that if a person or more so a child who fell from the tree, there would be some associated injuries like tearing of the skin, scratches, etc. She did not agree that the child did fall from the tree. In order for this kind of a fracture to occur, it required a high height of at least above 1 meter, but also it will depend on the velocity. Dr. Hans Meyer further testified in respect of the previous femur fracture as follows. The femur was commonly known as thigh bone. A large amount of force is required to fracture a femur of a child. Also, the same view is expressed that the said injury could not have been caused by falling from a tree. It required a large amount of force to break a femur, high bone, which means it can only be caused by a human being. The injuries observed by Dr. Yachat. When Dr. Yachat examined R, she observed that he had these injuries. He had some bruising under both eyes, a bruising over the right nipple, and a bruising on the left rib cage, which were older than 2 days. The explanation was given to her was that the child was injured Both accused testified that they were aware of the bruises which were underneath both eyes. And R got them while he was chasing the kittens at home. He bumped against the door. As to the others, they were not. Or when she was watching them. Injuries. Doctor, the death of R. That any of the injuries could have caused the more details of these injuries at the The factual dispute was the said injury or not. Accused one testified she also to pass what accused two must have followed him, then hit him with something on the head to make him unconscious, and thereafter hot him with hot water. That is why she could not hear level of accused one, and also from carriage for Jay, who was delayed in bringing the pajamas. The question was, washing up, and only then when he was done, if Jay was still not back, then go and look for him. Inside the hot water. He was surprised that the cold tap was closed. Take him out of the water. He had grabbed her by his upper arm. He then put some lotion, cream all over his body. He then took him to the back room. R then put his clothes without any difficulty. Report and pictures therein. The court asked itself, since accused two found R with his raised upper arm, why not under his armpit, which the court believes that it will give a better grip without hitting the child. Dr. Hansmeyer disputed that of both arms were inflicted at the time that the accused two was lifting the child out of the bath. However, they are more in line with the person who was holding the child down inside the hot water. More so that the child was severely bent at the back. She further disputed that the head injuries that I received could have been received several blunt on his head to such an extent that he had cerebral hemorrhage, which must have been caused by a very strong force. Like when a person is involved in a car accident, head-on collision, where the impact is very high. Our brain was Dr. Hans Meyer opined that it was no way that a person was unable to see those veins. With this degree of veins, the veins at about 6 hours without any medical intervention, he should be starting to be disorientated. Based on accused one evidence, the time that R fell into the water, and what Dr. Hans Meyer had testified that after a certain time, R must have started to become disorientated, and also when accused one checked upon him, wherein she said that R looked like he was disorientated. The court do not accept her accused one version that accused two must have followed R during the night when he went to pass water, then assaulted him and burnt him with water. When did accused one become aware that R was burnt? According to her testimony, when she got home, R was already inside the blanket sleeping. She testified that after accused one had said, "I fucked R for good this time," she went to check upon him, and she only saw a mark on his cheek. It was not big, and he spoke to him, asking him if he is okay, wherein replied that, "I'm fine, man." According to Exhibit F, his hand was red and his face was red. I asked Enlin, "What did you do?" He said, "What do you mean?" Whereby he replied, Exhibit L and J, it is clear that accused was aware or must have been aware that something was wrong with R. She has testified that accused did not allow her to do anything, as he was in a fighting mood and was angry with her, but she testified that at 11, when accused 2 was sleeping, she went to check up on the boys, J and R. However, it surprises the court that she did not thoroughly check R, notwithstanding seeing earlier those markings, red hand and cheek on R. At Exhibit J, paragraph 48, she had said that, "I have lived in constant state of fear from my co-accused, whom has repeatedly beaten me since my little boy's death, telling me over and over that he will kill my other children." Two. She does whatever accused 2 tells her. There is strong possibility that accused 1 was aware of what accused 2 was doing to R. However, Being afraid that she will lose her children, she did become a party to whatever accused 2 was doing. Accused 2 had a strong influence on accused 1. Accused 1 went to her parents to stay with them. However, at some stage, accused 2 came to her at her place at work, notwithstanding the fact they parted not in good terms. It surprises the court that she then decided to go back and stay with accused 2 again, up until they were separated. They were arrested. Accused 1 testified at some stage that during the time they were staying together, after the passing of R, they discussed this case, and if she answers in a manner that does not suit accused 2, he will tell her that that will not be right and it will put us in jail. Lastly, I wish to refer to Exhibit L, which is WhatsApp messages. In short, the tone in them is that accused 2 is threatening or fighting accused 1. He even went to such an extent as to say at a message that came at 2707-270610, Marley, everything you're saying is not true, but it's okay. I won't defend myself against lies. For a long time, I believed and defended you, only to learn that you were (0639). Emily replied, "Yeah, alcoholic, we will see. I have witnesses. You turned your back, nah? That's all you did. I killed R." When accused 1 was asked if he did not ask accused 2 what he meant when he said he killed R, accused said, "It was just a threat, nothing, it was not true." The court cannot accept that as a valid reason. There is a saying that the truth always comes out when people are fighting. According to accused 2, he also testified when he said, "I fucked him for good this time," he did not mean R. He meant that their relationship was now fucked up for good, which the court found it not to being truthful. If really their relationship was fucked up, the court believes that after accused 1 had left to stay with her parents, he would not have tried to make any contact with accused 1, since she knew how accused 1 felt about his ex-girlfriend. Conclusion. In the final analysis of the evidence before court, I'm guided by various legal principles to determine whether the charges against accused have been proven beyond reasonable doubt. The case of S versus Rady and others, 1996, SAR 1A 8C to E, the court held that in assessing circumstantial evidence, one needs to be careful not to approach that evidence upon piecemeal basis and to subject each individual piece of evidence to consideration of whether it excludes the reasonable possibility the explanation given by an accused is true. The evidence needs to be considered in its totality. It is only then that one can apply the oft-quoted dictum in R versus Blom, where reference is made to 2 cardinal rules of logic which cannot be ignored. Proof beyond a reasonable doubt does not involve proof to an absolute certainty. It is not proof beyond any doubt, nor is it an imaginary or frivolous doubt standard that must be met by the state evidence in criminal prosecution. No other logical and reasonable explanation can be derived from the presumption that a person is innocent until proven. In R versus Devers, 1944 AD 493 at 509, 508 to 9, it was held that a court should not consider each circumstances in isolation and drawn inferences for each single but that taken as a whole, the evidence is beyond reasonable doubt inconsistent with such innocence. In S versus Shackle, 2002, SABC 185, SCA at 194, the court states, it is a tried principle that in criminal proceedings, the prosecution must prove its case beyond a reasonable doubt, and that a mere tolerance of probabilities is not enough. Equally tried is the observation that in view of proof, the court does not have to be convinced that every detail of an accused version is true. If the accused version is reasonably possibly true in substance, the court must decide that matter on the acceptance of that version. Of course, it is permissible to test the accused version against the inherent probabilities, but it cannot be rejected merely because it is improbable. It can only be rejected on the basis of inherent probabilities if it can be said to be so improbable that it cannot reasonably possibly be true. In State versus Hadebe and others, the court enunciated the correct approach for evaluating the evidence with reference to Musepi and others versus R 1980 to 1984, close bracket, LAC 57 at 59 F to H. The question for determination is whether, in the light of all the evidence adduced at the trial, the guilt of the appellants was established beyond a reasonable doubt. The breaking down of a body of evidence into component parts is obviously a useful aid to a proper understanding and evaluation of it. But in doing so, one must guard against tendency to focus too intently upon the separate and individual part of what is, after all, a mosaic of by one. That aspect is viewed in isolation. Those doubts may be set at rest when it is evaluated again together with all other available evidence. That is not to say that a broad and indulgent approach is appropriate when evaluating evidence. Far from it. There is no substitute for a detailed and critical examination of each and every component in a body of evidence. But once that has been done, it is necessary to step back a pace, consider the mosaic as a whole. If that is not done, one may fail to see the wood for the trees. There is no onus on the accused to prove the truthfulness of any explanation which he gives, or to convince the court that he is innocent. Any reasonable doubt regarding his guilt must be afforded to the accused. The test is whether there is a reasonably possibility that the accused evidence may be true. The court does not have to believe the accused, still less does it have to believe it. It is sufficient if the court thinks that there is a reasonable possibility that it might be substantially true. If one takes the totality of the evidence, the court rejects accused two version that R fell by accident in the bath and also hurt his head and body during the time that he fell on it. In the circumstances, the inference that the court draws is that the evidence points out that R was abused during his lifetime. Dr. Hans Meyer found some injuries on R which were more than 24 to 48 hours, meaning R was assaulted not only on the day that he was banned, he was previously and constantly being assaulted, and that it was accused who had inflicted those injuries upon R, and he also banned R while he was holding him inside hot water. Please stand up. Was accused one aware of what was happening to R? Was she negligent, or was she party to what accused two was doing? She turned a blind eye to that. As the court has indicated above, that evidence shows that accused one must have been aware or should have been foreseen what was happening to R. However, Being afraid of accused 2, she became silent, and her silence caused the death of her son. With regard to count 2, that of murder, there is no evidence that she participated in the killing of R, or any inference that can be drawn that she did participate in the killing of R. However, as a parent, she deliberately neglected to give R proper care, notwithstanding the fact that she was aware that R was being abused, or even on the night of the 24th June 2016. Therefore, the court is satisfied, taking into account the entire conspectus of the evidence, that the state had discharged the onus resting on it to prove the guilt of accused beyond reasonable doubt. The accused version cannot reasonably possibly be true, is accordingly rejected. In short, accused 1 is found guilty as charged count 1, and in respect of count 2, he is found guilty to alternative count. That is, accused 1 is found guilty of 2 counts of contravening the provisions of section 305, subsection 3A of Children Act 38 of 2005. Accused 2 is found guilty as charged, that is, contravening the provisions of section 305, subsection 3 of Children Act 2005, and count 2, murder, read with the provisions of section 51, subsection 1 of Act 105 of 1997. And that will be my verdict.
My Lord, this state the state, in respect of previous convictions, wishes to prove no previous convictions in respect of accused number 1. If the relevant SAB 69 may be submitted, I believe it would be exhibit M.
And that will be exhibit M.
My Lord, in respect of accused number 2, the state wishes to prove the following previous conviction, that on the 4th day of May 2005, the accused was convicted of reckless or negligent driving and was sentenced to a fine of 2,000 Rand or 80 days imprisonment.
Mr. Are you aware of the said offense? If so, can you confirm and sign it? Negligent driving. Okay, can you kindly sign it for me? And that will be exhibit N. If I'm not mistaken. N. Approach. Yes, Mr. Smith. I'm still consulting. Thank you.
My Lord, it is my instruction that I ask the court to post. My Lord, I would like to ask leave of the court to extend the bail of the first accused.
Extend it when? Why? At this stage? You said it's your instruction to do what?
To extend the bail of
Before we come to the bail, why are we not doing mitigation on sentence?
My Lord, it is my instruction that I ask the court to postpone the matter for 4 weeks.
Smith, you will request when the probation officers report that the social workers and other for on meeting
Come and testify.
I hear you. And the second leg was asking for
the bail
to be
extended.
Why?
Because she has
Is it not that the situation has changed now? Because now she has been convicted. By that time, she was still awaiting trials. You have to give more. But anyway, let me hear also from the other side.
My Lord, we did compose a affidavit, a bail affidavit.
For now.
Showing special circumstances that exist why it's in the interest of justice that she
Yes. Not you, not Mr. Smith. I mean that two accused. Yes. We're still submitting, yes?
Yes, we have composed a affidavit for bail to show that there are special circumstances that's in the interest of justice that will allow her to be released on bail.
So you want to present an affidavit that you have. Do you have it now?
Yes, I have it now.
Okay. Just before, let me just get the opinion of the state and other, well, particularly the state. I want to ask if I choose to.
Lord, the court pleases, in respect of the application for the extension of bail, the state will be opposing such a.
Okay. That is. And you want to start the proceeding in that regard?
Yes, my Lord. If you want, I can hand up a copy of the affidavit to court.
Have you given the state or the other parties the copy?
Also have dates of argument, my Lord. Dates for you.
Yes,
My
sir.
Lord, did you receive a copy of the dates of argument?
With missing weights. And it's got some missing things on it. It's just, I have been convicted of the crime of blank. Blah, blah, blah.
Yes, my Lord, I didn't know what the accused would be convicted of today, and that's the reason why that's done.
So,
I can ask leave of the court and to postpone, to adjourn the court so that we can fill that in if need be.
adjourn now or postpone for another day.
Adjourn now.
give you that opportunity. Yes.
My Lord, just to place on record my understanding of Section 58 of the Criminal Procedure Act, until ordered otherwise by His Lordship, accused one.
That's the position. Thank you. You will complete it, then the court will resume. How long do you need?
My Lord, may I also ask leave of the court for a copy of the judgment so that I can fill in the crimes that the accused was convicted of?
And I can give you the last page, not the judgment at this stage. They will print it to you. My clerk will bring it to you. We'll make it available, the last page available. However, I've already seen some, but we'll talk about it when it comes back. There is something agree or see in this regard, but be as it may. And we'll take a short break. Mr. Smith?
From getting the relevant page of the judgment, I think 20 minutes is
20 minutes. I know it's 10 to 1, and unless the parties want to come back at lunch, after lunch, or we take that 20 minutes, work through, don't take break, and then once we are done, because number one, it's only an issue of a bail, because accused one has already asked or made an application to have the matter postponed to file his probation officer's report. I take it that maybe even accused number 2 will like the same or not, if I let me hear from you. You can have a seat, Mr. Smith.
I have canvassed the matter with my instructor, and it could seem from where we are at this stage that the court is so inclined to give the postponement, and in that regard, we have decided that we will also take the opportunity to acquire the services of a probation officer and or correctional supervision department.
Fine. So let me get this now. State, do we take 20 minutes or until after lunch?
My Lord, I'm in the hands of the majority and happy with either situation.
Okay. As I always do with democracy. I know Mr. Namazin. Yes, 20 minutes or after lunch?
20 minutes.
Mr. Smith?
20 minutes is fine.
Stenographer? Democracy. Both accused will remain in custody. Court take the 1:15. Court adjourned.
You might not give me the entire judgment.
Steve, I actually had a quick question. Filming of the accused is not the problem, but when we film the portion with the...
So we can film the accused?
Yeah, but when we deal with the names of people
surviving children. Yes, but by media law, by filming them and broadcasting their images, you're essentially identifying their surviving children, which is prejudicial to them. If you want them to sue you in the future, then they won't.
I think 50, he said 51 once, so the minimum is life in prison.
So you set a precedent here, well done.
I thought he would have convicted.
However, depending on the outcome tomorrow, accused number 1, you will stay in custody. So the matter is rolled over until tomorrow for accused number 1 alone, and for accused number 2 and 1 until 21st of January. So the court will stay adjourned until tomorrow. You'll be here at 9 or 10? What time? 10. 10. Court adjourned until tomorrow 10. Thomas?
Please.